Philip, I was regaling a story of years ago watching a kingpin in a major federal court case represent himself, and everybody else was represented by an attorney. But this guy was so engaging. Everyone was talking about what he was doing in front of the jury. Jury was laughing when he would make jokes and when he would go after the prosecution's witnesses, did some really funny antics in summation, and actually was found not guilty. And the other defendants with the lawyers were convicted. I would say that was because he established a tremendous rapport with the jury. I think you have a lot of thoughts about whether this defendant should have represented himself, knowing you as I do. So what are they?
Well, first of all, Bob, under what we call the Ferretta versus California waivers, one of them that the judge has to be sure of before allowing a defendant to represent himself is whether or not he truly understands the dangers involved. And this man clearly understood. And here he is now, this sort of self-styled attorney, probably from watching one too many episodes of Law and Order, thinking that he can endear and ingratiate himself to the jury, which is fine. And sometimes it works because the jury understands, oftentimes, in these pro-per representation cases, that David versus or David and Goliath effect. Now, having said that, he is trying to attack what I call collateral points. He is not zoning in on the very damaging direct evidence put forth by his own ex-wife. How is he going to explain away what she and the kids testified to? The fact that a spot of blood wasn't tested or that a cord wasn't looked at and all this other stuff does absolutely nothing to undermine the credibility of the percipient witnesses. He's done nothing to attack that. So I think he's in jeopardy here.